This because you're talking about the threshold and insignificant and trivial. I don't have the impression that, as found in this case, in Clay, they're really talking about insignificant and trivial. And if you look at the harm dealt with at page 34, 35 in the Court of Appeal reason, they talk about, first of all, triggering schizophrenia. They talk about bronchiopulmonary damage. They then go to Ledane. They talk about the impact on adolescents, a vulnerable group, as is described elsewhere. The impairment of psychomotor abilities that you touched on earlier. Said the heavy use, that's the 30 to 50,000 people, may result in a significant amount of mental deterioration and disorder. They then say the role of multi-drug use, and it says on the next page that 1 in 7 or 8 graduate from marijuana to cocaine and heroin. So, you know, these findings of fact that members of the court keep asking you about do seem to indicate something other than triviality. Now, admittedly, it is, as you point out, a subset of a larger group. But given that it is a significant number of people, I don't think the harm can fairly be said to be characterized by Ledane's.
Well, even accepting for the point of this submission that the harm principle, whatever threshold, whether it's not insignificant or the higher significant serious harm, is met by that subpopulation, you still are left with the problem of gross overbreadth, because the findings of fact the court also accepts and also endorses is that the other people that I've already identified are causing no harm, that there's nothing associated with their conduct, but they end up with the criminal sanction, the criminal record, and some go to jail. I just want to deal quickly with a couple of points about arguing that the law is not rational. One of the criteria that Justice Sapinka puts forward in saying, or in suggesting how a court should analyze the rationality or irrationality of a criminal prohibition under Section 7 is its efficacy or efficiency. And I just note parenthetically that the Crown's submission that this is inappropriate, relying, as the Crown does, on the Firearms Act case, is of no assistance, because the Firearms Act case was a division of powers case, and this court makes very clear that the analysis to be had under the Charter is very different. I would commend that to you. But turning back to Justice Sapinka's Rodriguez-type analysis of rationality of the law, I say for 3 reasons the criminal prohibition on marijuana fails also the rationality test, in addition to failing the overbreadth test. First of all, it's clear from the evidence that the criminal prohibition is no deterrent to the use of marijuana. So even if you want to protect that small subpopulation of users, the fact of the matter is the evidence shows it doesn't achieve that purpose. And I refer to the evidence of Professor Erickson. It's summarized at paragraph 28 of our joint statement of legislative fact, where on her studies, she found that 92% of those charged continued to use even after being charged, and I think it was while they were still under charge. So even if you want to protect that subset of people, the fact is at best, on the evidence, you're only going to maybe protect 8%, because the vast majority don't care about the criminal prohibition.
But aren't you deterring other people, perhaps, from engaging in that type of use?
Well, that's actually contrary to what her opinion is and her evidence is in terms of her studies, that based on her surveys of people and her field research, that the criminal prohibition does not create deterrence. In fact, the second reason I say it's irrational.
I have difficulty. I mean, how can you know that? Because at the present time there is a criminal prohibition. Perhaps if you had no criminal prohibition, then you might have means of comparison. But in the absence of that, how can you draw any satisfactory conclusion that the court can rely on.
But some of the studies have done that. They have done those comparisons between jurisdictions that have decriminalized as compared to jurisdictions that have maintained criminal prohibition. And in fact, the rate of use in the jurisdictions that maintain the criminal prohibition in many instances is double that in the jurisdictions where they've decriminalized. So in addition to Patricia Erickson's...
Are your jurisdictions comparable?
Yes, and that evidence is in the joint statement of legislative facts. They've done that kind of control. So the criminal prohibition doesn't deter. What it does do, and the second point why it's irrational, is the evidence shows that it engenders disrespect for the law by citizens who, as a group, are otherwise largely law-abiding citizens. That is, other than possessing marijuana or using marijuana, they are otherwise law-abiding citizens, but because of the criminal prohibition on marijuana, it has a backlash effect, and it engenders general disrespect for the law, for other laws.
I thought I had seen that the use of marijuana in Amsterdam was very high. Since it's decriminalized or legalized or not enforced, that the percentage use compared to Canada was high.
Quite the contrary, Justice Major. In fact, it's less than half. The percentage use, and this also is in the joint...
Is that measured against citizens of that country or just measured on total sales, if I can use
I don't know that I can actually answer the minutiae of it, but I'll just refer you to paragraph 57 of our joint legislative facts and just say that one of the many, and 57 right through to 61, studies by Patricia Erickson, one of the leading researchers in the area, Eric Single and Diane Riley, but one of the studies, summarized at paragraph 57, found that 12% of high school students in Holland smoke marijuana, whereas in Canada, the figure, and in the U.S., is in the high 20s. So indeed, it's not the prohibition that is somehow doing anything to accomplish whatever state objective there may be. The third, and perhaps most important reason why it's irrational, is even if you want to help, again, that subpopulation of users, criminalizing possession does not encourage chronic users, because that, again, is the subset that's at risk. Criminalizing possession does not encourage that group of people, the people with problems, to go out and seek help. Criminal prohibition sends the exact opposite message to them. It says, continue to hide your problem from society, because if we catch you, we're going to stigmatize you and you risk going to jail. If it's dealt with as a health issue, if the message goes out that you can't do this, we're not going to let you do this because you're going to hurt yourself and maybe there's going to be consequences to society, but we are going to offer you assistance, then in my submission you're sending the right message. The criminal prohibition sends the wrong message. I'm not going to deal with division of powers because I'm short on time. I'll leave that to either Mr. Conroy or one of the interveners. I want to deal quickly, if I might, with the one ground that's unique to Mr. Clay's appeal, the statutory construction argument. The best or complete description of the proper approach to construction of criminal statutory provisions is in Sharp. I won't take the court to it. But it's clear from what this court said in Sharp at paragraph 33, it's at tab 20 of the appellant's book of authorities, that contrary to the respondent's submissions, you can't simply stop in a plain literal interpretation of a provision. And I refer to the Skokie-Graham or Skokie-Graham case as a good example about why a court must always consider the statutory provisions purpose in interpreting it. And I will ask the court to turn this up. It's my brief of authorities, tab 22. It's a 1985 decision of this court at tab 22. And this, of course, was a charge of disturbing a religious service. Someone had insisted on kneeling when taking communion, which was contrary to church policy. That person held up the communion line, which annoyed the priest and some members of the congregation. The trial judge had readily found that that met the definition of disturbance in terms of disturbing the service. But this court rejected that simple, literal interpretation of the word disturbance. And I refer you to page 10. This is a decision of Justice Wilson. Paragraph 35. She says, I recognize that the appellant's conduct could fall within the ordinary meaning of the word disturb. Equally, it could be embraced by the definition of disturbance given in Black's Law Dictionary. I would point out that the American context from which the Black's Law Dictionary definition appears to be drawn is markedly different from the Canadian one, etc. Reading on the next sentence, not all conduct capable of being described as disturbing or creating a disturbance will fall within section 172 sub 3. To found criminal liability under this subsection, the actions must meet a definition of the term disturbs, in quotes, suitable in law to the context of the section and the offense thereby enacted. It is necessary for the conduct to be disorderly in itself or productive of disorder to be rendered criminal. Conduct which falls below this threshold will not be caught by the subsection. That was read in by the court implicitly because a very literal definition of the word disturb or disturbance would overshoot the mark and criminalize conduct which presumably didn't cause harm.